Equal employment opportunity laws prohibit specific types of job discrimination in certain workplaces. The Department of Labor has two agencies which deal with equal employment opportunity, monitoring and enforcement: the Civil Rights Center and the Office of Federal Contract Compliance Programs. In June 11, 1963, speech broadcast live on national television and radio, President John F. Kennedy unveiled plans to pursue a comprehensive civil rights bill in Congress, stating, "This nation, for all its hopes and all its boasts, will not be fully free until all its citizens are free." King congratulated Kennedy on his speech, calling it one of the most eloquent, profound, and unequivocal pleas for justice and the freedom of all men ever made by any president. The earlier Civil Rights Act of 1957, the first law addressing the legal rights of African Americans passed by Congress since Reconstruction, had established the Civil Rights Division of the Justice Department and the U.S. Civil Rights Commission to investigate claims of racial discrimination. In an article published after the 1963 March on Washington for Jobs and Freedom that posed the question, "What's next?" King wrote, "The hundreds of thousands who marched in Washington marched to level barriers. They summed up everything in a word: now." Following Kennedy's assassination in November of 1963, King continued to press for the bill, as did newly inaugurated President Lyndon B. Johnson. On January 4, 1964, a column in the New York Amsterdam News, King maintained that the legislation was the order of the day at the Great March on Washington last summer. The Negro and his compatriots, our self-respect and human dignity will not be denied. The bill passed the House of Representatives in mid-February of 1964, but became mirrored in the Senate due to a filibuster by Southern senators that lasted 75 days. When the bill finally passed the Senate, King hailed it as one that would bring practical relief to the Negro in the South and will give the Negro in the North a psychological boost that he sorely needs. On July 2, 1964, Johnson signed the new Civil Rights Act of 1964 into law, with King and other civil rights leaders represent. The law's provisions created the Equal Employment Opportunity Commission to address race and sex discrimination in employment and a community relations service to help local communities solve racial disputes, authorized federal intervention to ensure the desegregation of schools, parks, swimming pools, and other public facilities, and restricted the use of literacy tests as a requirement for voter registration. The right of employees to be free from discrimination in their compensation is protected under several federal laws. The one that we're going to talk about now is the Equal Pay Act of 1963. The Equal Pay Act requires that men and women be given equal pay for equal work in the same establishment. The jobs need not be identical, but they must be substantially equal. It is not job content, not job titles, that determine whether jobs are substantially equal. The Equal Pay Act looks at specific factors such as skill, effort, responsibility, working conditions, and establishment. Skills are measured by factors such as experience, ability, education, and training required to perform the job. The key issue is what skills are required for the job, not what skills the individual employee may have. Effort is the amount of physical or mental exertion needed to perform the job. Responsibility is the degree of accountability required in performing the job. Working conditions encompass two factors: one, physical surroundings such as temperature, fumes, and ventilation, and two, hazards. The Age Discrimination Act of 1975 prohibits discrimination on the basis of age in programs and activities receiving federal financial assistance. The Act, which applies to all ages, permits the use of certain age distinctions and factors other than age that meets the Act's requirements. The Age Discrimination Act is enforced by the Civil Rights Center. The Age Discrimination of Employment Act of 1967 protects certain applicants and employees 40 years of age and older from discrimination on the basis of age in hiring, promotion, discharge, compensation, or terms, conditions, or privileges of employment. The Age Discrimination Act of 1967 is enforced by the Equal Employment Opportunity Commission. Passed by Congress in 1990, the Americans with Disabilities Act is the nation's first comprehensive civil rights law addressing the needs of people with disabilities, prohibiting discrimination in employment, public services, public accommodations, and telecommunications. EEOC was given enforcement authority for Title I Act, the Employment Discrimination Provision. Since 1990, they have settled many litigation causes, such as a 1993 consent decree resolving a claim alleging disability-based distinction and a union's health insurance plan which limited lifetime benefits for AIDS to $50,000, while providing benefits up to $500,000 for other catastrophic conditions. In this case, the defendant company and union agreed to pay $100,000 for medical expenses and damages and to remove the limit on AIDS coverage retroactive to the ADA's effective date. A 1993 jury verdict finding a security firm had discharged its executive director because he had terminal brain cancer, although he had continued to perform the essential functions of his job. On behalf of the charging party, EEOC secured $220,000 in back pay, compensatory relief, and punitive damages. In 1997, jury verdict finding that Walmart had discriminated by refusing to hire an individual who used a wheelchair because of his disability. As part of its evidence, EEOC introduced a videotape showing the charging party performing many physically challenging activities during his daily life. The jury awarded $8,399 in back pay, $75,000 in compensatory damages, and $3.5 million in punitive damages. And last example is a 1999 jury verdict against Chuck E. Cheese pizza chain, where the commission alleged that the defendant discriminatorily discharged an employee because of his mental retardation. Although the employee was able to work productively with the aid of a job coach, and the local manager and staff supported his retention, the employee was fired by a regional manager who stated that the company did not employ those kind of people. Ultimately, EEOC won a jury award of $10,000 in back pay, $70,000 in compensatory damages for emotional distress, and a record $13 million in punitive damages.